So I'm Kim Talus, professor at UEF Law School and University of Helsinki. I've worked with pipelines and other cross-border infrastructure, both in my academic career and as well as in practice. And I'm also advised specifically Nord Stream 2 on the application of EU law to this pipeline. Now, today I'll talk for about half an hour on Baltic Sea pipelines and EU law, and then we have about half an hour then for questions and answers. And while you can already start typing the questions, I'll answer them then at the end of my presentation, or at half an hour through the presentation. The focus of the presentation is slightly more on Nord Stream 2, because I have to assume most of you will be more interested in that pipeline, although from a Finnish perspective, for the Baltic perspective, also our other pipeline, the Balticconnector, is an interesting project. So all in all, Baltic Sea at the moment is very interesting from a pipeline world perspective. So let's see how to, there we go. So this is what we are talking about. Two pipelines. One connecting Finland and Estonia. One connecting Russia and Germany. Now I'll run through some of the technicalities of these pipelines and then look a little bit at the applicable law or the regulatory framework for these pipelines. So the first pipeline that we'll talk about is the Balticconnector, and you'll see it from the map connecting the Finnish and the Estonian gas grids. So Balticconnector, it's a 77-kilometer offshore pipeline between Finland and Estonia. In addition to the offshore bit, it also has onshore portions, both in Finland and in Estonia. The total cost for this project is 250 million, and in 2016, European Commission granted it a funding of 187.5 million euros. This corresponds to 75% of the total costs. The daily transportation capacity of the pipeline will be 72 million cubic meters per day. Now, this capacity needs to be compared to the current capacities to Finland, which is approximately 23 million cubic meters per day. So from a Finnish perspective, this pipeline is significant. The gas can be transported bidirectionally, and the idea is that it will be the usage will be based on market demand. The plan is to have this pipeline operational in 2020. Now, the rationale for the pipeline. The rationale for the pipeline depends a little bit on from which angle do you look at the project. From an EU rationale, the idea is to integrate the Baltic Sea region with the rest of the EU gas transmission system. So integrating energy islands into the main grids. From a Finnish national perspective, this is not a standalone project. It relates to the gas market opening of Finland. So far, we've had a monopolistic system based on Article 49 of the Gas Market Directive, and this is now coming to an end. The new Market Act that will introduce competition to both wholesale and retail markets is currently with the Finnish Parliament, and is expected, or the government bill is with the Finnish government or Finnish Parliament, and expected to become law later this year. Now, if we look at the website of the Balticconnector, the stated rationale there is to improve regional security by diversifying gas sources. Now, at the moment, Finland is 100% dependent on Russian gas coming through two pipelines connecting directly to the Finnish grid. This pipeline will allow, at least at some stage and at the moment in theory, the usage of Klaipėda LNG terminal and also the gas from other parts of the EU. That requires, though, that any internal bottlenecks within the Baltic region are also dealt with. The stated rationale is also to create a framework for market opening, growth, and enable use of alternative sources such as LNG and biogas. LNG I already mentioned. Biogas in Finland is a growing source of energy, and my assumption is that then this pipeline would allow transporting this gas also to the Baltics. Finally, it enables interconnection of the Finnish and Baltic gas markets and their integration with the EU's common energy market. But of course, this also means that internal bottlenecks and then the connection between Lithuania and Poland is completed. The regulatory context for Balticconnector is relatively simple. It appears on the list of projects of common interest or common European interest, so it's a PCI project, which means that it has access to a favorable regulatory treatment under the PCI regulation, which has been also implemented, or the details have been implemented into the Finnish system. It's also receiving the money, as I mentioned, from the Connecting Europe facility, which corresponds to 75% of the costs. Now, there's no separate intergovernmental agreement for this pipeline. It is currently owned by both Finnish and the Estonian gas companies or government-run companies. And the operator for this pipeline at the moment is still unclear. Given that there is both territorial waters, exclusive economic zones, and then territorial waters on the other side, in my opinion, the applicable laws to this pipeline have something to do with the ultimate control of the pipeline and the operatorship for this pipeline, which, as said, is still unclear at the moment. Now, then we move to Nord Stream 2. So that's the basic introduction to Balticconnector. Nord Stream is a slightly larger project. It's a 1,200 kilometer offshore pipeline connecting Russia and Germany, as I showed in the first slide. Total costs is in the range of 8 billion euros, so slightly more than our Balticconnector. It's also supposed to be operational in 2020, so matching with Balticconnector in that respect. Total capacity of both Nord Stream pipes is 55 billion cubic meters of gas per year. It's a Swiss company owned by Russian Gazprom, and it has now financing agreements with a consortia of EU companies. The stated rationale for Nord Stream 2 is to ensure a highly reliable supply of Russian gas to Europe. Regulatory context is slightly more complicated than what it is for Balticconnector. So the question of the applicable law has been discussed in the media and in the academic circles for a number of months or even years if we consider Nord Stream 1 discussions as well. You can approach this question, in my opinion, from three different levels of law. You can look at international law, and there primarily the UN Convention on the Law of the Sea. You can also There are other international law instruments that apply, but I'm not going to go into those. You can look at this from European Union laws, and you can look at European Union energy regulation. Here, primarily, I'll talk about the natural gas market directives and the other gas market related regulations. You can also look at it from a national perspective, and then you look at the treatment of EEZ in Finland, Sweden, Denmark, and Germany, and you look at the territorial waters and laws there for Denmark and Germany. And this is what I propose to do next. Under the UNCLOS 1982 regime, you have a separation between territorial sea and exclusive economic zone. Territorial sea, you have a full sovereignty, only subject to those exceptions that are mentioned in the treaty itself. Exclusive economic zone is something very different. There, coastal states have a functional sovereignty. So in the EEZ, all states have a freedom to lay submarine cables and pipelines. Coastal states can take action that is allowed under the treaty. So they relate to environmental considerations mostly. So you can act to prevent, reduce, and control of pollution from pipelines. The coastal states also have a say in the delineation of the course of the pipelines, but they don't have the right to stop the pipeline from being put into their EEZ completely. The UNCLOS does not allow the coastal states in the EEZ to regulate the operations of the pipeline. Now, EU law, of course, or the jurisdiction of EU law follows the jurisdictions of its member states. And in the case Commission versus United Kingdom, in the Habitats Directive, the conclusion of the court, or the finding of the court, was that Habitats Directive applied in the EEZ of UK. This is natural because the Habitats Directive relates to environmental considerations, and they are among those factors that fall within the competence of coastal states. So, if we then move from international law to European law, the question first is, what is Nord Stream 2 pipeline? It's not an upstream pipeline because it does not fall into the how do you say that in English? It's not within the definition of an upstream pipeline. It's not an interconnector, even if technically it is an interconnector, but the definition of an interconnector is that it crosses or spans a border between member states. And given that Russia is not a member state of the EU, and probably never will be, it's not an interconnector under the EU energy law. Is it a transmission line? That's a more difficult question, and for that we need to look at the details of the law, and we need to look at the existing practice relating to coast-to-coast pipelines. So, for the content of EU law, we can look at the capacity allocation network code, which is the Commission Regulation 984/2013. Capacity or network codes are the most detailed level of EU regulation when it comes to operational issues in pipelines. And specifically, Article 2.1 of this regulation, or the network code, specifies that the regulation shall apply to interconnection points. But then it says that it may also apply to entry points from and exit points to third countries. But this is subject to the decision of the relevant national regulatory authorities. So I would argue that there was never an intention to apply EU gas market regulation to these offshore pipelines bringing gas to the border of EU. And the existing practice confirms this. I haven't listed all imaginable pipelines that could be listed here. I've just put in two. Transmed pipeline, which is an existing pipeline, and Gulf pipeline, which is also, well, it's a planned pipeline, both in the Mediterranean Sea. In both these cases, the supplier and part owner of the pipeline is the Algerian national company Sonatrach. And to me, this suggests that EU energy law is not applied to these pipelines prior to their connecting into the gas transmission systems in the downstream EU. Now, if we look at other pipelines, if we move away from coast-to-coast pipelines, we can look at Southern Gas Corridor project, and here the EU law is applied only to those sections which are within EU borders. So Trans-Adriatic pipeline, which has an exemption. But it's not applied to those parts which are outside of the EU border. So it seems to me that EU energy law is not applicable to these pipelines prior to their connection into the downstream system of EU. Now, if we look at national laws, the Finnish Act on Exclusive Economic Zone lists all the laws that are applied in the EEZ of Finland. Gas Market Act or Natural Gas Market Act is not on that list, and therefore it is not applied in the EEZ of Finland. Swedish EEZ Act has a similar situation. The Natural Gas Market Act of Sweden is not applicable in the EEZ of Sweden. Danish Natural Gas Act, on the other hand, specifies in Article 2.4 that the Act does not apply, or is excluded from the scope of the Act, those transmission networks in the territorial waters or the EEZ that are not connected to the Danish natural gas system. So explicitly, Danish national law excludes the application of Danish Natural Gas Market Act to Nord Stream 2, which does not connect to the Danish pipeline system. So, to conclude about the applicability of EU energy law, if we look at the international law approach, EU law applies. Environmental laws of EU, yes, but EU energy law, or the third package, does not apply to Nord Stream 2. If we look at EU energy law and regulation, the wording, the intent, and the practice suggest that the third package is not applicable. And if we look at the laws of the coastal states, Finland, Sweden, Denmark, it's the clear wording of all the national laws is that they do not apply to this pipeline. So what would it mean if EU energy law would apply to the pipeline, to any pipeline, coast-to-coast pipeline connecting EU and a third country? It would mean that third-party access would apply, it would mean that unbundling provisions would apply, and so on and so forth. And the ownership structures, for example, in a oil and gas producing country are among the key decisions, key sovereign decisions that a country would make. In terms of Algeria, this was done immediately after the independence. And so these are very significant decisions. And we have to remember that there's a difference between energy policy and energy law in upstream and downstream countries. Both of these approaches are legitimate. They are just very, very different. The rationales, the policy objectives of an upstream country and a downstream country are completely different. So these are serious consequences for an upstream country. And so in my humble opinion, they would be very controversial in all our energy partners' governments. Now, I move to a separate but related topic, because European Commission has, at least it seems so, or is going to be asking the member states for a mandate to negotiate a Nord Stream 2 specific intergovernmental agreement between EU and Russia. Now, the first specific, or the logical question is a specific intergovernmental agreement necessary? My answer to that would be it's not necessary, but it is an option. It can be done. If it would be done, it would be, from the EU side, initiated through the mechanisms under Article 218 of the Treaty on the Functioning of the European Union, where the Council, under qualified majority, would vote to give the Commission a mandate and some negotiation guidance or directives, as I think they are called in the article. Because this would be a mixed agreement, at the end it would still be ratified by all national parliaments, and therefore unanimity would be required at the end. And because of this, my understanding is that the Council will also seek unanimity immediately. And this is not the first time we have this situation of an intergovernmental agreement being proposed for a pipeline. We also have the example from 2011 of the Trans-Caspian pipeline system, where the European Commission had the mandate to negotiate an intergovernmental agreement between EU and then the Caspian states. Unfortunately, that decision from the Council is classified, so we have no information on the exact content of that example, which is unfortunate. Continuing with the intergovernmental agreement, if this type of intergovernmental agreement would be concluded, what would it then include? According to the press releases or press reporting on the topic, the Commission is suggesting that in order to prevent what the Commission calls a legal void, an IGA should cover the offshore section of the pipeline. It should cover both building and operation of the pipeline, and it would be based on some fundamental principles stemming from EU energy law. Reading the words fundamental principles stemming from EU energy law, I would understand it to mean third-party access, unbundling, transparency, and these type of considerations. Now, the difficult issues that I see with this approach is that it would extend the application of EU energy law outside the EU borders without an overall plan on how to do that and without the involvement of European Parliament. Now, if we start extending the application of EU energy law to non-EU or energy community countries, that should be done through a specific plan. And even then, with a plan, we would run into difficulties of the downstream energy law and policy being so different from upstream energy law and policy, we might also lead into other different types of problems. And if we look at the impact of these things in the EU market, one has to note that all the gas volumes that are moved through these pipelines are subject to EU energy law once they move into the downstream pipeline system of EU. Now, the final point here is that if an intergovernmental agreement is not adopted, then I would not speak of a legal void. The legal regime and that situation is based on international law, European Union law, and also the national laws of all relevant coastal states. And what the operational regime would then be would depend also on the operatorship. So I think it's technically wrong to speak about a legal void in that situation. To conclude briefly, two very, very different projects. The other project, the Balticconnector, is mainly driven or exclusively driven by public sector involvement, and financing is coming from the public sector. The other project is purely a private sector initiative, although Gazprom is a government-owned entity. The European partners, together with Gazprom, are financing it from private funds. At least that's how it seems to me. For the approach of the, let's say, European Commission or EU, the other project is high on the priority list, connecting these energy islands with main EU grids. And for the other projects, the Commission and some of the member states are highly critical. So two very, very different projects being constructed, planned and constructed at the same time, and should become operational at the same time. And all within the Baltic Sea. So Baltic Sea is an interesting area at the moment from the pipelines perspective. Now, I would invite you, so this is actually, I'll show you one more slide. There is two papers that I've written on these topics. The other one is called Application of EU Energy Law to Certain National Laws of Baltic Sea Countries to Nord Stream 2 Pipeline Project, published in Journal of World Energy Law and Business earlier this year. The other one is called An Intergovernmental Agreement for Nord Stream 2, Rationale, Content and Impact. And this was also published earlier this year, actually not very many days ago, in OGEL, which is an online journal.